Pues muy buenos días a todas las personas que nos acompañan de manera presencial el día de hoy y en línea. Hoy es el segundo día del Foro Académico sobre Competencia y Regulación Digital, los desafíos de las políticas regulatorias para plataformas digitales y sus ecosistemas, organizado por el Programa de Regulación y Competencia de Mercados Digitales del LegalTec Lab de la Escuela de Gobierno y Transformación Pública. Como lo mencioné en la sesión de apertura del día de ayer, el Programa de Regulación y Competencia de Mercados Mercados Digitales es un espacio neutral que busca fomentar este debate progresivo sobre el papel de los mercados digitales y su interacción entre la competencia, la regulación, la innovación y el comercio electrónico. Este programa busca apoyar, como lo pudieron ver ayer, la cooperación y coordinación entre los diferentes ámbitos público, privado y social. Bueno, y estamos, realmente nuestro equipo está respaldado por un escenario multidisciplinario y el entorno intelectual entre académicos, profesionales, reguladores, legisladores, todas las partes interesadas, la industria y los consumidores dentro del LegalTec Lab. Bueno, el día de hoy vamos a tener dos conferencias magistrales y un panel muy interesante sobre el futuro regulatorio de Big Tech, Telecom y Over the Top. Y a continuación vamos a tener una conferencia de Christian Ketona. Good morning, Christian, and thank you for accepting the invitation to participate in the academic forum. Christian is Vice President of Global Competition and Regulatory Policy at the Computer and Communication Industry Association. He holds a law degree for the University of Virginia School of Law, the University of Constance in Germany, Paris de Panthéon-Assas in France, and Fred-Fus-Laurent University in Hungary. Christian has more than 17 years of experience, including serving at the U.S. Federal Trade Commission as counsel for the International Antitrust, responsible for multilateral antitrust affairs and cooperation with Europe and Brazil. In 2019, he served as senior FTC advisor at the Administrative Council for Economic Defense, which is the Brazilian antitrust agency. In addition, he served as an attorney in the FTC Technology Enforcement Division, investigating and litigating potential violations of the antitrust law and high technology markets. Previously, he worked on antitrust and competition matters in the Washington, D.C. office of Weil, Gotshal, and Manges, focusing on international mergers and investigation of alleged anti-competitive conduct and civil litigation. Thank you, Christian, for being here. The idea is to listen to your 30-minute presentation and then on over-the-top regulation in the digital economy, and then we turn to questions and answers, and then you can go to the airport. Is that perfect? Does it work for you?
That's perfect. That sounds like a great schedule.
Thank you. So you have the floor.
Sure. Thank you so much. Y muy buenos días a todos. And I think with that, I'm done with the Spanish here. But good morning to everyone. And it's really a wonderful opportunity to join all of you today. I'm just sorry that I can't be there with you in person. But again, I would like to thank the LegalTec Lab and the Tecnológico de Monterrey School of Government and Public Transformation and Eileen for the kind invitation and really the opportunity to present as part of this morning's discussion. Now, turning to our topic today, and in my discussion, I obviously will focus on platform regulation in the digital economy. I think, first and foremost, this discussion really couldn't be more timely. And what we see is that we see everywhere from trade press to the general news that competition, but in particular digital competition, I think perhaps has never been more hotly discussed and debated than these days. And my initial remarks will really cover four main issues. First, I will start with providing some background and context of digital competition globally. And second, I will discuss the very important interrelationship of international regulatory proposals, what we see worldwide. And really, I want to highlight kind of like the importance of individual jurisdictions really not relying on international regulatory experiments, which has been a serious concern as of late. But then third, I will also discuss and underscore the importance of cost-benefit analysis when thinking about regulatory proposals in this space. But I also understand that the cost benefit analysis discussion was also part of your discussion yesterday at this academic forum. So I will not go into a lot of details on that, not to repeat some of the points that were discussed then. But then last, and as my fourth topic, I will really zoom in a bit specifically on Mexico and Latin America and also emerging economies, and think about competition and regulation from the perspective of Latin American jurisdictions. And I just have a couple of thoughts in that regard too. So with that overview of my key points and the issues I'm planning to cover, again, I will start providing a context of some digital competition issues globally. And again, what we really see is we're seeing a number of significant antitrust developments worldwide. And that includes enforcement actions, important enforcement actions, policy initiatives in a number of jurisdictions, and competition regulatory proposals as well worldwide. And this includes really a number of countries. That includes the United States, the EU, the Union, of course, a number of and some of individual EU member states, for example, Germany, that have been having proposals in this particular area over the last, year and a half, but also a number of other jurisdictions from Japan to Australia to South Africa. So we really see a lot of activity worldwide in this space now. But I think it's important to highlight that many of these global developments focus on digital antitrust and competition issues in the technology sector specifically. And I would really want to start briefly discussing some of these recent international developments in digital antitrust to provide some context. First, I think as many of us are well aware, just a few weeks ago, the DMA, the Digital Markets Act, was adopted in the European Union. And the DMA really imposes a stringent ex-ante regulatory regime on specific companies, so-called gatekeepers, offering services in the digital sector. But it's important to see that in some other jurisdictions, there's really an ongoing discussion regarding really how to address potential regulatory concerns regarding digital markets. And there are various legislative proposals on the table in many countries. Currently, there are various proposed bills in the US Congress as well, focusing on digital platforms. And I just want to underscore, I think it's about 8, 9, or perhaps even 10, of these proposals that have been floating around US Congress for the last year and a half in this congressional, period. But I think it's important to highlight that although in their names, some of these proposals are often called competition bills, they are in fact what I would consider regulation, disguised regulation. And I think perhaps the one that has been discussed most often lately is AICOA, the American Innovation and Online Choice Act. So these US bills and proposals are at different stages of their development in US Congress. But importantly, none of these bills has been adopted yet, and their future is rather uncertain in that regard. They touch upon a number of relevant issues, and we could spend a lot of time talking about the individual issues. I will not go into a lot of details on all of them, but a couple of the issues I would highlight in a number of them is really a ban on self-preferencing as an activity, but also ban on, in some of these proposals, a ban on mergers and acquisitions of companies over a particular size. So what we see is that many of the US bills, including AICOA, they would actually prohibit most forms of self-preferencing by large platforms, which, as you know, is where the platform gives more favorable treatment to its own product than to competing products. And it's interesting to see that we regularly see self-preferencing in many parts of the economy. One obvious and really often cited example is a supermarket where, for example, the store puts on display, either by the entrance or highly frequented places in the store, its own private label product. Or a very common example that people often talk about as well is, for example, a shopping mall where, of course, the mall owner might own a shop in the mall as well. But we see self-preferencing really as a generally pro-competitive or at least competitively benign business conduct in a number of industries, in addition to healthcare to banking and financial services, and really it's a long list of industries where it's really a common business practice. And what we really see is that in instances where self-preferencing might become anti-competitive, for example, when the conduct might suppress nascent competitors, ex-post competition enforcement really has been able to address this particular issue for decades. And the US's famous Microsoft case, many of you are familiar with as well, is really a perfect example of how antitrust enforcement has been able to deal with this issue in case the conduct, self-preferencing itself, might become anti-competitive. But turning to the digital context, I think it's very important to highlight that based on the US bills that are currently in Congress, this ban on self-preferencing could mean that, for digital companies, for example, Google or Apple, really couldn't list their own apps first in search results in their app stores. Or, for example, Amazon couldn't list its own products before other competing products. And the language in this proposal is really vague. So self-preferencing could potentially apply to just about any actions that treat one company's or one platform's own products differently than those of competitors. So just a little bit more on the current bills in the US. Under these bills, it seems that really the only clear-cut way for a platform or a digital company to avoid legal scrutiny may be to stop selling its own products. But importantly, that obviously would require us a lot to sacrifice on competition and innovation. And in a number of these bills, there's a similar ban for covered companies over a particular size to acquire others. So that is basically a ban on company mergers and acquisitions. And when I discuss these particular elements, I think the key point is that when we talk about potential threats to competition, it's really crucial that this threat to competition must be demonstrated and not merely assumed. When we think about, in an exclusion case in antitrust, normally, we ask the plaintiff to demonstrate two things. One, market power, and second, some indicia of anti-competitive effects. But then the current US bills seem to omit the first of these requirements, market power in all cases. And interestingly, they omit the second one, some indicia of anti-competitive effects in most cases as well. Specifically, if you think about like the draft bills, they ask whether a technology company is large, but not whether it actually has the power to exclude rivals in the specific product market. And the other important element is that the majority of violations codified by the bills really don't require plaintiffs to show that anti-competitive effects are likely. Instead, it seems that in the bills, these effects are simply presumed. So when it comes to ex-post competition enforcement and this constant discussion about like the right balance or the fine balance and the balancing exercise between ex-post competition enforcement and ex-ante regulation, I think zooming in on ex-post enforcement and competition enforcement, as enforcers know, it's not unusual for antitrust cases to be complex and fact-intensive. But the important element here is, I think there's some echo. But importantly, we don't usually have, can you hear me well? I just want to make sure, because I think I hear echo. Yeah? I will carry on, but here's some echo, so I hope you can hear me well. So when it comes to ex-post competition enforcement, I was saying, as enforcers know, it's really not unusual for antitrust cases to be complex and fact-intensive. But again, we don't usually have these investigations unless we have a reason to believe that the defendant's conduct might pose a serious threat to competition. However, absent specific evidence to that effect, I think it's clear that we have little reason to assume a serious threat to competition in cases alleging activity, for example, self-preferencing. And I think that's the important point, that that's the same with the review of potentially anti-competitive mergers and acquisitions versus just banning them outright. But then, as a result, under the proposed US bills and just kind of like closing in on US developments, it seems that whenever a large technology company would introduce a new product, it would actually face litigation threats for any perceived special treatment of its product, even if the potential impact on competition is likely negligible. And the real concern here is that this would really discourage companies from bringing new products to market. And if we think about it, what and who would be harmed in the end? Obviously, it's the public that could be deprived of new products due to these bills. And innovation would be harmed. And in a broader context, competition and the economy and economic growth as a whole would be harmed. So now a key concept of the EU, the DMA, the US proposals, and also the number of international and foreign proposals is who actually would be covered by them. And that's really the key question if one thinks about it from a risk management perspective for companies and antitrust counsel and attorneys alike. So the question is, which companies would be designated as the so-called covered companies in the United States? Or in Europe under the DMA, which companies would be considered gatekeepers? Or in Germany under Section 19A of the German Competition Act, which companies would be of so-called paramount significance to competition, and so on with the different proposals worldwide. And on this, I would really add that another key question is like, what would be the potential costs of these proposals to the economy? And on that, I would add that a recent study by NERA, the National Economic Research Associates in the United States, finds that the US antitrust bills would cost the US economy up to about $390 billion over time. And this study really concludes that these costs would ultimately be passed on to consumers in the form of higher prices. So when one thinks about these proposals, I think it's really important to step back and think about, again, what the potential costs and benefits can be and would be. And then when it comes to different companies that are so-called, like covered, for example, based on the US proposals, it seems that the US bills are messaged as just targeting particular technology companies. I think it's about half a dozen of them if one looks at the market capitalization language. But the NERA study reveals that the language that really relies on market capitalization means that more companies would be captured in just a few years. So perhaps it's just a half a dozen companies now, but it seems that potentially there could be about 13 additional companies that would be covered in the next 5 to 10 years under the US bills. And likely it can be several dozen or perhaps even more than 100 companies that would be covered under the new bills by the 2030s. So that was kind of like my first part of my initial remarks. But now I'd like to turn to the second topic of my initial remarks, which is the interrelationship of international regulatory proposals and the importance of jurisdictions really focusing on their own economies and not relying on international regulatory experiments. So in that regard, I think it's very important to underscore that while it can be very useful to study certain jurisdictions that are leading the charge towards regulation of the digital economy, it's really important that as we think about competition and regulation, that jurisdictions around the world do not assume that the example of the first mover or perhaps the most active jurisdiction would be the best choice for consumers of the specific country, who are obviously subject to different competitive parameters than consumers in other jurisdictions. And we see that the market characteristics are very different, and they can be very different in individual jurisdictions. The competitive dynamics in individual markets, again, can be very different. And simply consumers' clicking habits can be, and as we see, they are very different as well. So in this sense, it really is crucial to avoid relying on international regulatory experiments in this area. As I mentioned before, we see that digital reforms are being considered in various jurisdictions. However, it's really important to underscore that as of today, only one jurisdiction, which is Germany, has introduced an ex-ante regulatory framework in this regard, which was part of Germany's 10th competition law amendment that took effect last year, actually as of January 2021. And what we really see is the results of this reform in Germany are also not really available yet after a little more than just a year and a half or so. So it's less than 2 years. In that regard, while it's really clearly useful to understand international proposals and their dynamics, I think a very important element when we think about competition regulation internationally is that the concern and the context to those reforms in different jurisdictions is really often lost. For example, some proposed reforms are really the result of particular political dynamics. And there are also emerging concerns about the impact of digital-specific reforms. Also, other international reforms, such as the DMA, that obviously there's a lot being discussed about, the DMA is also approaching implementation now, which, needless to say, will introduce further issues and challenges as those reforms take effect. For example, just one important implementation challenge and concern that has been voiced about the DMA is a double jeopardy concerns, which on the one hand would mean, like there could be investigations under the DMA on the one hand, and under, like national competition laws of European jurisdictions, there could be, like potential investigations of the same conduct of European national competition authorities on the other hand. So all of these issues, obviously, as part of the implementation challenges, will have to be addressed in the coming months, years. I think we really have to look at these developments on the global scale and really how interrelated they might be or might not be. And I think talking about competition enforcement and international convergence or divergence, I think it's very important to understand why a particular action might be a competition violation in one country, but not in another, when the facts are identical. But of course, if we step back and think about it, the facts in different jurisdictions are rarely identical because the market dynamics are different. So different outcomes based on different facts and different market conditions really shouldn't be seen as divergence among jurisdictions. But continuing this thought, when it comes to digital antitrust, there are some features that really throw the international convergence, divergence question into greater contrast. First, when we think about the companies being investigated, they're often global, whereas agencies themselves are of course, national. And this can be a very serious element when there is a political sentiment of deglobalization and focusing more on national interests, which you really can see now in a number of countries today. And we all should see that, and it's very important, that competition simply doesn't exist in a vacuum. And that also applies to the fact that it doesn't exist in a political vacuum. We have to see that many of the proposals that we see worldwide when it comes to regulation, they're in response to broader political objectives and significant centrifugal forces in that regard. But then second, and importantly, many of the concerns relating to technology companies that are often discussed and cited, for example, online harms, I think it's very important to underscore that they have nothing to do with competition. As we know, competition policy and enforcement. I worked for 15 years at the US Federal Trade Commission, as Eileen mentioned, until very recently. And a very big focus of my FTC career was on international cooperation issues and policy convergence among jurisdictions at bilateral and multilateral level as well. And what we really see over the last few decades is absolutely remarkable in trade regulation worldwide. and that is that it has been a true explosion of competition enforcement regimes worldwide. Just remember that, just about 3 decades ago in 1990, there were about 20 jurisdictions actively enforcing their antitrust laws worldwide. Today, there are 140 or even more jurisdictions with active enforcement regimes in antitrust. So that's a huge change just within a couple or a few decades. And as most countries now have competition laws and established competition agencies, we see that many of them, fortunately, have been very successful in building a competition culture and becoming a very important part of the market economy in their jurisdictions. But, and very importantly, I just want to highlight that it seems that with recent trends and developments, perhaps, some of these competition, like developments lead to the fact that agencies and enforcers in some countries potentially can be also victims of their own success. What I mean by that is it seems that there is a temptation to use these days competition tools when the perceived harm is not necessarily a competition problem. In many countries, new laws and regulations are being enacted to address these issues. But in others, as we see, competition is being used to address these issues. And again, it goes back to the question, are there distortions to the market that competition really has to address in that regard? And from a political perspective, competition agencies that really have been successful in enforcing antitrust and competition laws, what we see is now they're often asked to address issues beyond their competition expertise, remit, and responsibility. And working with a number of jurisdictions worldwide, I sometimes have heard the comment of something must be done, and the competition agency should be the one that does something. And it hasn't been once when I heard that comment, which is very interesting, because if we really have to think about it, I think we really should define if there really is an underlying market distortion issue, and if so, whether it's a competition issue and antitrust should be used to address the potential underlying issue or not. On this, I also want to add that to me, it seems that, especially over the last couple of years, perhaps we moved to a world in which the expectation is that competition enforcers are perhaps more like ex-ante regulators that need to solve every perceived problem even before it arises, instead of actually clarifying the law and setting a standard by saying, here is the line of competition violation and you shouldn't cross it. From that perspective, I'm somewhat concerned that competition agencies are perhaps in some jurisdictions losing the focus that the job is not to address every single competition issue in the marketplace. As we all know, that's an impossible task. The task is to try and have a system that has robust competition and is very competitive. And if there are particular issues, competition-related issues in the competitive system, the competition enforcer steps in and addresses those issues. And I think for the last several decades, the US economy has been very competitive and innovation has been thriving because there has been a good and robust system of ex-post competition enforcement. And really, there has been a regulatory framework that has allowed companies to really compete on the merits, which, as we know, is the key goal and objective of competition. So as we're thinking about all these important issues, I think we again should be reminded by what the US Supreme Court said, for example, in the 1966 Grinnell decision, that growth or development as a consequence of either superior product or business acumen is not a violation of antitrust laws. In fact, that's the objective of a robust competitive system. So after that, now turning to the third main topic of my initial remarks, I will briefly discuss costs and benefits, as it's important to consider that introducing new regulation for platforms is really not costless, as we can see, especially given the dynamic and innovative nature of digital markets. And in that regard, the global experience shows that there are many interrelated issues and potential concerns, which really, in this space, touch upon a number of different policy areas. So, in addition to competition enforcement and policy, these regulatory proposals often have significant ramifications in areas such as data privacy or national security or cybersecurity, and intellectual property can also be significantly affected by certain provisions. And of course, this actually may harm competition, consumers, and innovation as a whole. And in that regard, the broader national economy as well. We see that, for example, and I had a couple of pieces on that, like in articles too, with the AICOA bill in the United States, among other issues, it raises a number of very important and unaddressed data privacy and national security concerns as well. So it's well beyond competition too. But because of this, it's very important that new regulation should only be introduced after a comprehensive analysis of the costs and benefits. And this should involve an assessment of whether existing tools in the toolbox, such as use of existing competition, consumer protection, and data privacy laws, are actually sufficient to address any potential issues, or are there any gaps these existing frameworks do not actually capture? And to ensure that the cost of any new regime doesn't outweigh its benefits, the rule should really allow conduct that is clearly pro-competitive or competitively benign, or that is in need for security and privacy protections. They really should recognize justifications for legitimate protections, such as user safety, security, quality, and functionality. Because without such appropriate safeguards, an ex-ante regime may outlaw legitimate and pro-competitive forms of conduct as well. And that would be to the detriment of consumers and businesses that use these platforms and services and practices. So I know you covered many of the relevant cost-benefit points as part of the discussion yesterday. So we'll actually move on from this point then to the final topic of my remarks, which really is focused more on Latin America and in particular, and Mexico specifically. And in that regard, as we think about these important issues, as key considerations and perspectives that competition policymakers should keep in mind in Latin America, I think we really should step back and remember the fact that is really widely acknowledged that, in the first place, digital platforms provide consumers and businesses tremendous benefits. And given the dynamic and innovative nature of digital markets, any new regulation for platforms really needs to take into account, like wider potential implications for businesses and consumers alike. In that sense, it's very important for policymakers in Mexico and Latin America, as well as in other jurisdictions, to really thoroughly assess whether the benefits of any proposed digital platform regulation would really outweigh its potential negative impact for consumers and the economy. And why is that? And that's because an overly burdensome and heavy-handed regulation could really significantly hinder innovation and harm economic growth in a country, as a number of examples and historical examples from a number of jurisdictions shows from the 20th century. But speaking with policymakers and stakeholders about some of these regulatory proposals globally, lately I hear more and more of a sentiment that really underscore the need for a more nuanced approach in emerging markets in particular. So just yesterday, I was actually speaking with an antitrust practitioner from another Latin American country who mentioned that a very important point that made me further think about these issues, how individual Latin American economies, as he mentioned, might not have what he called the luxury to experiment with regulatory proposals that really might easily become too burdensome for companies that often are international that operate in the country. And why is that? And that's because an overly burdensome regulatory framework would really make it difficult for foreign companies to comply with the requirements, which often might not be even particularly clear what the requirements are. And these additional hurdles could very significantly hinder doing business in particular countries, which could then, of course, hurt the broader economy and economic growth. And on that point as well, additionally, and specifically in Latin America, I just want to mention that it's so important to consider a deeper interagency policy integration with a regional focus. In this sense, it's really crucial to better understand each other and the policy initiatives or the like research as well that's done in different jurisdictions. It's because of really this to promote a better understanding and exchange of views and research results that this academic forum here by LegalTec Lab, I think it plays such an important role in this dialogue in competition, regulation, and digital economy. Just as another example, a few weeks ago, I was in Bogota, Colombia, where the Javeriana University, CCIA, my association, co-organized a similar discussion with authorities and leading practitioners on current opportunities and challenges in competition regulatory policy, focusing in particular on digital antitrust issues. But it's just so important to share the results of research programs and the work of academic centers and hubs in the region, including here at the Tecnológico de Monterrey, and to have this exchange with the authorities as well in the region, in the country, in the broader region as well. So that would make it kind of like an exercise from which, the academic research could make, like helpful, valuable additions to what agencies are doing, but also for agencies to share their viewpoints and thinking on these very important issues. As such, again, it's so important that you're hosting this two-day academic forum today to share these experiences and learning, and especially from a comparative and international perspective. So again, it's a true pleasure for me to be able to participate in it. And I think those are my initial remarks. Thank you very much. Muchas gracias for that. And I look forward to any questions or so you may have. Thank you very much.
Thank you, Christian. ¿Hay alguna pregunta en alguien? I have a question.
Please.
Taking in account what you said during your presentation, it seems that sometimes the bills target the same companies and they share some common regulatory features. So taking in account that there are various, that there are various jurisdictions, some bills propose, for example, size as the sole determining factor for regulation. Other propose, for example, ignoring the consumer welfare standard, or they propose prohibiting standard business practices once firm reach a certain size, and we can go on. So, in that sense, what can you talk a little on how some of these bills impact far more firms than their primary targets?
No, that's a very good question. I think it also relates to some of the studies that I kind of like referred to as part of my remarks. I mean, I think I mentioned, like this NERA study, for example, this National Economic Research Associate study, that if you look at kind of like how the particular language of the proposals, whether it's the DMA, whether it's in the United States, the AICOA, the American Innovation Online Choice Act, actually provides the details. It usually uses a market capitalization language. And in addition to that, it might have, particular provisions or language regarding number of users. And that's the kind of language that we also see in some of the proposals or so. And then in that regard, like when one thinks about the particular kind of like snapshot picture, these would be the covered companies as of today. But again, if one thinks about like how or what's been happening in the marketplace, it's obviously a dynamic environment in which we see changes, and often very rapid changes in a short amount of time. So if you look at kind of like the continuum of the market economy, especially in the digital marketplace, if you would have drawn any similar kind of like through a different or similar exercise, like kind of like particular threshold numbers a few years ago, you see how over time new companies that would be added to that particular list of covered, like companies, or in the, like under the DMA in Europe, so-called gatekeepers, or in Germany, the companies that would be considered under 19A of the Section 19A of the German Competition Act, so-called companies with a paramount significance to competition. So over time, based on the market capitalization language in short, medium, and long term, there would be a number of additional companies added to that list. And then despite the fact that perhaps now, as you mentioned as well, there might be particular companies that are being targeted in this exercise. And I'm not even going to kind of like the competitive neutrality and discrimination related points to that, how competition really shouldn't apply to just particular companies versus others in the marketplace. But then the interesting element is how over time that would just increase. And then, for example, the NERO study says that just over the next couple of years, 3-4 years, the likely, based on the market cap language, there will be additional 13 companies added to that just in the United States. And then by the 2030s, there could be additional dozens or so. So I think it's very important to think about the costs and benefits in that regard as well, that whatever regulation is being proposed today, it would potentially apply in a significantly different economy and economic environment a few years down the road. And that's what we see, even if we just think back to a few years, like what would have happened with similar types of proposals and how the market economy has changed over time, without adding additional elements that are truly kind of like unpredicted, such as the last 2 years with, like a pandemic significantly changing the whole digital environment. But how things have been accelerating will have a significant impact on how potentially additional companies can be added to these types of, like requirements.
Thank you. I don't know. ¿Alguien más tiene preguntas? No, I don't think. There's a question there.
Sure.
Thank you. For you, competition authorities are the ones who must establish the regulation. I mean, like do the enforcement of that regulation ex ante for big companies? Because you mentioned that it's very difficult for competition authorities, like to see every problem, no, that is going to come. So I didn't understood that part.
Yeah, no, it's a very good question. You actually see, thank you for that, but you actually see a number of different examples in different jurisdictions, kind of like how these proposals are being born, or kind of like how some of the proposals are being run in governments, like of different jurisdictions. So one kind of like, key element is what I mentioned, that, competition agencies and the competition authorities in a number of countries are kind of like leading the charge in thinking about these types of competition regulatory issues, potentially providing new types of ex-ante regulatory frameworks. In other jurisdictions, as we see, and I'm in contact, with, or focusing on a number of different global initiatives in that regard, it might be not the competition authority, but potentially, for example, the Ministry of Trade or the Ministry of Economy that has been focusing on kind of like a broader national digital agenda. And as part of that is thinking about potentially, new types of regulatory proposals. And in some of those jurisdictions, potentially the Ministry of Trade, Ministry of Economy, or some particular arms or ministries of the government actually works in consultation with the competition authority to create some proposals or to come up with new regulatory framework ideas. So there's no kind of like one size fits all approach. And I think that's what you also see in a number of jurisdictions, and I would say it's a key concern to make sure that, when there are particular proposals, whether it's the DMA, whether it's others that, again, haven't really been, applied yet, and there's been limited experience with them, they haven't been implemented yet, countries don't just kind of like take them on because it's just so different how different competitive dynamics and individual jurisdictions and their consumers behave, and how companies are in other jurisdictions. So it's really kind of like a broad mix of things. You see a number of different examples worldwide, but there's not kind of like one main type of approach or one type of example. Competition agencies usually play an important role in this process, but sometimes it's run by, like kind of like ministries. And on that one, I also would add is, I think I mentioned that briefly as kind of part of my remarks, but you really see a number of economies creating kind of like these broader national, like digital agendas. And there's this kind of like push that you see in a number of jurisdictions for kind of like these agendas to really apply new thoughts, new principles, new tools, when I think it's so important first to step back and understand, are there actually issues that need to be addressed? And if so, how those should be. So all the discussion, you know, on cost-benefit analysis, of having a good assessment of the comprehensive, you know, outcomes or so of any proposed bills relates also to that as well. I hope I answered your question.
¿Alguna otra más pregunta? No, I think these are all the questions. Thank you, Christian. I think you gotta take a flight, so thank you.
I do.
Yeah.
Thank you for
so
being
you have
aware
to
of
run to the airport. We will have you here next year, so.
I'm looking forward to that. And again,
Yeah.
thank you so much for the invitation. It's been a pleasure
to see you soon.
participate in this. And good luck for the rest of the discussions. I see you have a fantastic program lined up. So I'm sorry I can't be there in person, but I hope to see you all very soon. Thank you very much.
Thank you. Bye.
Thanks. Bye-bye.
Bye.